by 3:12.
Yeah.
All right. As in the past meeting, influence or rudeness will not be tolerated. Members will be given a chance to speak after a motion is seconded and before a vote. Members will be given 3 minutes of floor time. The two things on the agenda today to approve the signing of the stipulation to the Dec judgment and the easements regarding the flood wall.
Pete, when were those? Well, that's the first thing I've heard about 3 minutes. When were those rules of order passed?
Oh, isn't that Robert's Rules of Order?
Oh,
That you keep, saying?
I think
So
it probably
have
is.
3 minutes?
Not necessarily, no.
Okay, well, we'll give you 3 minutes. Is that sufficient?
I'm asking you when these rules were adopted.
Well, we try to follow them, but this is what we're doing.
Okay.
Okay, would anybody like to make a motion?
Yeah, I'll make a motion
I'll second.
to approve the signing of the stipulation to the declaratory judgment action.
I'll second
And this is with the proviso that there is no waiver by the association of its rights if the court does not rule in favor of the city. And the second.
that. I second it. Okay. Any discussion?
Well, yes, I'd like to go if I may, and I'm not sure that I've seen those rules that you just elucidated, Pete. I think on an important issue, there's $40 million of property value. I would hope the board would take a little more time to consider these issues. But let me just...
You got the floor, John.
Yeah, I do have the floor. Thank you, Pete. Let me just explain why we're here and why we are not off doing far more productive things that we've been trying to do since we came to Prescott. We, after living in 18 communities, came to the first meeting of this board. Not everybody here was present, but we were threatened with a lawsuit. It's the first time that we've ever entered a community by having that happen. Do I have the floor? We had the ridiculous saga of the lawsuits, and I agreed to volunteer pursuant to a board resolution of this board when I had lots of other things to do, and it was the board's resolution and invitation, it wasn't me volunteering, to research the low water crossing. I can't tell you how many times I wish I'd thought to tell the board at that time that I had far better things to do and to leave the matter entirely to you. But basically, I took the heat on that. I took the leadership role on that. That was something the board didn't feel they were able to do. And frankly, I took the risk. Took the risk that what we'd uncover would be rather unpleasant. If it were unpleasant, it would be a problem that we would walk towards rather than walk away, which I believe this board has actually done. The status at the moment is that after all that research was done, a lot of time spent by myself, including in this room here where the presentations and conclusions were given with your blessing on video, we're all being sued by the city, whether you like it or not. The lawsuit that you did not want to have happen has happened. You're a defendant, and unless you sign a stipulation, and every other defendant in this lawsuit signs a stipulation, which requires the defendants to agree to the version of events as proposed by the city, you will be sued, and you're liable according to the city's presentation for substantial legal expenses. In our case, as you know, we may be the only people in the whole of Arizona, and we're actually not, because Jim Musgrove's firm agrees with us in written form, that believes some wrongdoing was done here. The Attorney General, as you know, doesn't care, the voters don't care, you seemingly don't care, but we're on record, and we're on record at your request. In this forum here, where I made some very substantial allegations, which you all blessed, on record ahead of that. Back to why we're here, and I'm sure we all have better things to do. How are we affected? Well, we're affected because we stood up and exercised our First Amendment rights. And our First Amendment rights are something as newly minted citizens we actually in the past have benefited from substantially. We were told in the very first meeting that, I think Judy was actually present, about the litigious nature of the seller's family. This was our welcome to the crossings. The reason for that was because we had a substantial piece of litigation where somebody threatened us and abused our constitutional rights, and we had to go and fight that and win a fraud case. So we feel a certain responsibility, if we don't all, to the First Amendment. The second is that, having gone on record, and again, we may be the only people, except we're not in the state, that believe
3 minutes.
I'm going to carry on, Pete, unless you interrupt me. There's substantial reputation risk here.
We're done. We're done.
Well, we're not actually. I'm going to carry on.
No, sorry. We're done.
Well, let me just finish. There's substantial reputation risk here. Pete?
Would you like to say anything?
Well, why don't you let him have his say and
Okay.
go
Go
from
ahead.
there?
Thank you. So there's substantial reputation risk. In my business capacity here, there are a certain number of mayors down in the valley who are well aware of what's going on here. And I just don't have the flexibility to be able to stand up and say, only kidding, because actually we don't believe that. We're also, and the board has steadfastly denied the existence of this, for 2 years have been saddled with a $1.3 million cash investment, not a mortgage investment, as some board members were, but a cash investment that's been totally useless to us, totally unavailable for the purposes of securing mortgage financing, and frankly, totally incapable, or leaving us totally incapable, of following the mayor's clear directive in the July 27th meeting of please leave town. So we will be defending this case simply because, based on the way that we're affected, we have no choice. We really don't have no choice. And frankly, in the same way as we were threatened with the US Supreme Court by the Ekmark and Ekmarks 3 or 4 years ago. Pete, you remember this ridiculous situation. We were being threatened with a substantial lawsuit. We had no choice because of the issues involved to put a substantial part of our net worth aside and deal with the issues and let the dice fall as they may. So that's what I have to say. I have some questions of the board, if I may, but I'd be happy to leave those until a little later in the interest of trying to respect the time limits that you wish to set.
Whatever questions you have, you can submit for the next meeting. The
Well,
others
these-
were answered. Questions you submit for this meeting,
Well,
they're in writing on the back table.
they may well be, but these are issues exclusively. This is a special meeting.
Yes.
These are issues exclusively germane to the stipulation.
You knew about this meeting. You could have submitted them 10 days before in writing. As requested.
I would
So-
like to submit the questions, and if the board chooses to ignore them, I've taken the time to put the questions together. And I'm sorry, is there something that we missed on the way in? Some questions that we were...
Well, we've got them right there. You know, the answers to your questions that were submitted are in writing.
Maybe we could discuss those and see whether they're fully
Well,
addressed.
we're not at the meeting, we're just,
Not going to discuss it. The answers right here.
they're in writing right there. But thank you for your time. Thank you for your input. Okay, going forwards,
Before you have to vote, if I ask you a question, if you sign the stipulation and all this goes forward, does anybody have an idea of time frame by which this will be open?
to see,
Okay, the other question is the dedication for everything, the road access to the public will now be going across, is all has to be addressed by council as well.
yes.
Do you not understand or think you understand everything about public access under something or over something that's owned by the HOA?
We're under advisory from our attorney because there is pending litigation. We're advised not to talk about it. We have to contact our attorney.
I'm sorry, that,
Contact Atkinson. He's the attorney handling the situation.
well, without getting any depth of conversation, have the subject of the bridge covering been broached by you guys with Atkinson, is that being discussed and considered?
The bridge crossing,
The bridge
Covered
The
covered.
covered bridge, the covered bridge is remaining.
Yes, but you have the same situation going on in my mind is when you own it as
What do you mean, the
an
deck?
HOA,
Are you
that
talking
you
about the
still
deck?
have public access liability under that bridge.
The road
you have.
deck.
So
Is that what
what-
you're asking? The road deck is part of
Not
that.
the road deck, the bridge covering, the bridge itself.
The bridge covering is ours. It belongs to the crossings. We own it,
I
we maintain it.
understand, but we also own the low water crossing, we also own the road deck that goes under the bridge covering. You still have a problem legally with public access over top of the road deck. That is a problem because by the rules out there, I understand that it is a real problem that we own it. So the same as if we owned the road deck and they weren't
Oh,
taking
I
it.
understand that. Your question with this agreement is, the way it's supposed to go is the city's gonna take back the road water.
Yeah, I understand that in the road deck, but they're not addressing the bridge covering. And
The bridge covering, we own
is
it.
equally liable as the road covering itself because you have public access under it. And I'm just asking,
Yeah, no,
has
we
that
own-
situation been discussed with Atkinson?
Everything's been discussed, but the bridge covering we own and we maintain. It's got nothing to do with the city.
Yes, but it's the same
It's a
situation.
liability.
Same thing.
Anything
And
is.
then the question is, I'm not gonna argue with you with it, about it.
No, we're not arguing.
Has he opined in writing regarding the bridge covering itself?
We own the bridge covering.
No, I'm asking you something you're not answering.
You're saying give it to the city?
No,
City doesn't
I'm
want the bridge
asking you
covering.
if Mr. Atkinson has given you a written opinion regarding the status of the bridge covering and his application.
No,
No.
that was never in question. The bridge covering is owned by us. It has nothing to do with the city.
You also own the roads underneath.
It's the road deck is
Same
totally separate.
liability exposure if there's ever anything that goes wrong. And I
Mhm.
think it should be discussed with Atkinson in depth. If it's something he feels that is out of his area of expertise, then he has to do something.
The road deck,
The liability.
the
is
liability
same.
on the bridge is ours. We own the bridge, the covered bridge. We will continue to own it, and most people in the community want that. That's a centerpiece of the community.
Now, you keep saying that, but you've never had a vote, so how the hell do you know?
We have input from the community. I told people in
Again,
the
give me
community.
some numbers. You have to have a vote to tell me that most of the people in the community
I know
want it.
you were suggesting to get rid of the covered bridge. It's the centerpiece of the community. It just, you
Yes,
know,
but it could be established over in the open ground area where there's no public access.
where you can put it. In a
We
creek?
have 25 acres.
You have open area,
Well,
it could be relocated.
Thank you.
It could become a picnic area that's affording covered access to people.
I'll look into your,
But I think the legal liability is the same for the bridge covering as it is for the road deck, the low water crossing. It's a legal question that should be addressed. And whether most people feel, I agree with you, it's very, very unique. I like it, but I don't like the liability works. So I'm just saying it's a legal question that should be addressed.
Mr. Chairman, I have a question, if I may. This list of questions that you've just, the answers which you've just literally I obtained a copy of, really is not relevant to this meeting. This is a list of questions that will be more appropriately dealt with as general association matters at the next meeting. But there were some questions submitted that were very specific to the stipulation, and these are not addressed here. And they were submitted within the 10-day deadline. So may I raise those questions?
no.
So
Submit them writing for the next one.
they were.
You should have-
Mr. Chairman.
This is it. This
No,
is
no,
what we
no,
have,
no, it's
George.
not. No, it's not. I beg to differ. There is a series of questions raised.
Sorry.
Sorry.
Mr. Chairman.
Next, okay.
Mr. Chairman, I'd like to raise the issue of Scottsdale versus Mocho. There's a question which was submitted within.
John,
3 minutes.
You know what? It's time. Please leave the meeting.
No, this is a public library.
Well, if you don't want to, please stop.
I would like to leave.
Okay,
I would
all
like.
in favor of approving
You
That
can't
judgment.
have a vote without hearing from the public. Hello,
just
I
did.
have my hand up. I
Go
haven't
ahead,
said
Deborah.
anything yet.
Go ahead.
Why do we have a board that sits there that decides it's going to make votes after it has to have a public meeting? And A, it doesn't allow anybody to talk for more than 3 minutes. It doesn't allow anybody to ask questions. Therefore, it doesn't allow anybody to discuss anything. What is the point of us being here if we have to sit here and say nothing?
You could submit your questions 10 days.
We
before
did.
voting. That's
They're
what
not
it was.
addressed. Pete,
You're
I
not
beg to differ.
answering our
You
questions. In
there-
fact, you're
there
not
are-
answering
Pete,
anything.
Pete, the issue that you have not addressed is the very one that Mr. Atkinson does not want to ask. It's the question that was submitted within the 10-day deadline related to the legal validity of the 2003 plat, even if everybody agreed with it. There is a substantial legal issue there. That question was raised to this board within the 10-day deadline. It is not dealt with here. It's the issue of Scottsdale versus Mocho.
Okay.
Now you're proposing to, as I understand it, Pete, you are proposing to take a vote on a substantial legal issue which was raised within the 10-day deadline, and you're ignoring it, and you have not responded in this document here.
John, I'm under advisement from our attorney that your questions got to be submitted in writing 10 days before.
They were.
Not to answer any other questions.
Oh,
I'm
just
sorry.
your questions?
Just
No,
my
this is
questions?
All questions, all questions.
What is that question?
The question you get.
Would you like to know what the question is? Because it was submitted 10 days before this meeting.
Does it have to do with the stipulation?
Absolutely. Absolutely.
What is the question?
Well, you'll find it's number 7. Has the board obtained an opinion, as this was all raised in the email I sent over 10 days ago, has the board obtained an opinion in the light of Scottsdale versus Mocho and the memorandum rulings germane to that, that the 2003 plat would be a valid form of dedication, even blessed by us all? And if you recall, this was the email that came with a copy of those documents. And it was the letter that I wrote where I said, in effect, this is probably the one document that you might not even want to read. You might want to give it straight to your attorneys. But the question is, have your attorneys opined on this legal issue? Because it's pretty fundamental.
And the answer to that is yes.
What did they opine?
Writing? No. They have not.
So, okay, so Mr. Atkinson has opined on this.
He has advised us on it.
And what was the advice?
That is not something that has anything to do with this particular issue of ours.
So despite the fact that you were put on notice that some very substantial attorneys, and again, I'm not an attorney and this is not an issue I would rely upon my legal reading of documents, despite that, you've taken the advice of Mr. Atkinson that this very substantial piece of case law is to be ignored.
It says that law is not germane to the issue we're facing.
He has.
Case law.
And the justification for that?
He's our attorney, and that's what he said.
And we go by his.
I go by his judgment.
Okay, then let the record show that Mr. Atkinson volunteered an opinion on that, and I commend you for not getting into the legalities of that because it's a little complex. So it seems that Mr. Atkinson is the source of all knowledge on that. Thank you.
Okay. All in favor? Any other questions?
Yes, who will sign the stipulation?
I will.
And have all the board members declared a conflict of interest in regards to this stipulation being signed?
John, we're done.
We do not have a conflict of interest.
So the board, all the board members take.
We do as far as you are concerned, but as far as we are concerned, and as far as we have been advised, we are not in conflict, and we are in agreement with this stipulation.
You'll have to explain the question why you're in conflict with me.
All in favor?
Because you're the one who says we are.
All in favor
Aye.
of accepting? Aye.
Aye.
Let the unanimous 4 out of 5. Okay, next thing. Has everybody got the easement agreement?
Yes.
Okay, so make a motion.
I make a motion to authorize Pete to sign the approval of the maintenance of the drainage flood wall of the easement granted by the 4 property owners and to authorize Pete to sign the easement agreement.
I'll second. Any discussion? Go ahead, Debbie.
Do we get to see copies of the drainage easements?
Yeah, they'll actually be on the block. Be on the block.
We actually have copies of
Well,
them.
What is
actually,
Commerce Park? Is that part of our subdivision?
it is the commercial part of.
Oh, the Commerce, okay.
All in favor? Aye. Okay. Meeting adjourned.
What about the open forum?
I just had it.
We did.
Yeah,
No, we didn't. We talked about drainage easements.
yeah. That's the only two subjects on here.
No. Item 5.
Just a question on the Commerce Park and easement. At what point along there do they have to grant an easement? Is it by those folks that are in that first house from the Crossman Brothers?
Perkins and Ashcroft. And the easement for access for inspection of work.
Where the dermatologist is?
The dermatologist.
The
people
car
behind-
was down there. Right.
Well,
The
he
people
did say
behind
any
them.
questions, but
Yeah.
I don't even know the name. I'll tell you the name, but
Okay, further.
the people behind them, they put
they
a
have to make a motion.
Cabinet.
cap.
Yes.
And they're also going to be using on them because they're digging a trench to tie in with the large one to protect that whole first area.
Pete, before you move on, I'm sorry. The item of drainage easements was discussed. This meeting is being recorded, as you know.
Yeah.
And certainly in response to any questions, I treated that as item 4. I still view item 5 as the open forum as being open for discussion.
Yeah.
Okay, go ahead.
So, is it open or not?
Go ahead.
Okay. Well, I'd like to give the floor to anybody else first. I don't want to monopolize the conversation. Deborah?
Yep.
Oh, no, I'm sorry, I'm not gonna be held to 3 minutes.
We don't want to speak.
I'm choosing not to speak for
Okay.
2 minutes.
Go ahead, John.
Well, again, these lists, these items here, this list, we don't need to waste time today. The purpose of the meeting today was to take a very major decision, and you guys have clearly thought about this. So I would suggest that this list of items, ranging from the behaviour of the managing agent to, I mean, these are items that belong on the next agenda.
Are you talking about the questions that you submitted and the answers that we had?
Yeah, they're totally irrelevant to today. These are not matters.
You're absolutely right, it's irrelevant to today. However, you did submit those questions and you've gotten the answers. There's no reason to discuss it at this or any meeting.
I beg to differ. That's
That's
what
what a meeting
That's what a meeting is about.
Yeah,
It's
but
give
You'll
and
have
take,
other-
it's
you'll
considered
have other
conversation.
questions,
Well, I would be
or
bringing
you
the.
do not like the answers, maybe, but
No,
those particular questions have been answered.
They haven't actually. I beg to differ. I can just glance at them very quickly and see they haven't. I'm just
We're
making.
not going to expand on
But
the
we're not
answers.
going to discuss.
Well, then-
The answers
then-
are the answers. We do not
Then
discuss them in
we will.
writing.
Then may I?
I'm sorry, you
may-
got the answers there in writing.
May I
We
speak?
are not going to expand on them.
May I speak?
You have your 3 minutes and your
Thank
3
you.
minutes are up.
I don't believe they are actually.
Yes, they are. Sorry.
I didn't hear the bell go off,
No, you still got it.
and I was interrupted, so I'll recover my time. I just want to make the point that these items here are. These should really be discussed, and we will certainly plan to bring them up. You may consider them as having been answered, but they're not. There's also a number of issues that I uncovered today in the course of the records search. I have a little note here for you, Pete. I'll give this to you as addendum to questions. I won't take up too much time, but basically the substantial issue that's raised in there is the question of the board meetings that have been discussed. I did provide a list to DHB of the board meetings. I'd just ask you to confirm that. And then I also had the question, which didn't come up, but I wasn't allowed the time, of why certain defenders with regards to the stipulation have been served default notices and others haven't. But I guess that's not something that concerns you greatly. And lastly, I'd just like to make the point that this homeowners association is not conducting matters in an open and transparent fashion, and I yield the rest of my time to the floor.
I have a question, actually, which will take less than 3 minutes. And that is, why is DHB management being paid $1,000 to make copies of emails when they can email them at the cost of nothing, which takes one finger stroke? Why is the board paying DHB additional money to make paper copies of emails that should be emailed?
That's the answer on question 1 right there. If you like, I read it. Want me to read it out?
Sure, read it out.
Pursuant to its agreement with the association, DHB bills at $50 per hour for any special projects. The numerous requests by John Sellers for the association records have resulted in the association having DHB spent 13.5 hours to date in 2011, which is $675 in preparing the requested documents. Those requests have also resulted in the association paying the Carpenter Hazelwood firm fees to review the records to be processed. There are additional inspection requests from Mr. Sellers pending.
Right, but DHB management has been told many times by us to just email us the stuff. He doesn't have to waste paper or waste 13.5 hours or waste our association dollars. And you don't have to respond to that. I'm simply making a comment. We're supposed to have a management company that is current with local and up-to-date business practices, which means that all he has to do is go into his computer and hit a couple of buttons, and it takes a nanosecond to send that stuff, not 13.5 hours. That's my comment.
Now, I would add that 13.5 hours were billed, and I, on the statutory deadline today, requested all records to be provided to me. Mr. Balzano is sufficiently versed in 13.5 hours of preparing email records that he didn't even appreciate that email records are records of the association, and these were not supplied within the deadline today.
They're in a box, John. Unfortunately, the box is right on the table.
Then why didn't Deborah answer the question?
Why didn't I answer that?
Deborah's not there to answer questions. Deborah was there to monitor your review of the records.
So every email to date was in a box under the table?
Every email that you've been provided with so far, including all the correspondence that went from Mocho to you, is in a separate box.
Oh, no, I believe me, I went through that. But my request to you was all records. That would include all emails. They were not supplied today.
I don't just indiscriminately pull all emails off my computer or Deborah's computer and pass them on to any owner. They have to be scrutinized for confidentiality and for attorney-client privilege.
Then please do that, because that was the request I made with the deadline today.
Well,
That's what you
I
got.
didn't.
Because the attorney
No.
went through.
No, I'm sorry. Look, I was there. The answer I got from Deborah today, she spoke to you, was that you did not understand that emails were records, and you'd only seen the email I sent yesterday.
yeah, email that came yesterday, the day before, that you wanted all relevant emails. And I'm going to have to backtrack in our system from the last cutoff that I did for you and move forward with that. Screen those emails as I just described up to current date.
Well, then please do that.
I intended to do it.
But it wasn't done by the deadline today.
No, I'm sorry, I just got your request.
You did not know. My point is, you did not know the emails are records of the association.
Yeah,
And why didn't you supply them?
simply because I've supplied you with all up to a certain date, and I got to backtrack into my records when that was. And I don't do 24 or 48 hour turnaround time.
You had 10 days.
I got 10 days from that day of the last email.
You got 10 days from the date of the original request. What I'm saying is, here's my point of substance.
Anyway.
You charged, you did not supply the emails today.
Thank you.
You have to make a motion.
You have to make a
Make a
motion.
motion to adjourn the meeting. Anybody second?
Second it.
All in favor? Aye, thank you.
I know the meeting's closed, but just procedural things always interest me. Do you not keep electronic file? Do you reduce everything to printing it out? Or how does that work insofar as the records?
Emails are pertinent to a specific owner. Jim Atkinson, I print out a paper copy and put it in the corporate file. If the owner requests, and I do have electronic files.
Of everything?
Yeah.
Yeah. Okay. You don't like